morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with the Labor Attorney Jung Bo-soo, we will discuss about a particular article published at the Mail Labor Daily today. It's regarding the distinction between the full-time employee or like part-time worker. And this is a very sensitive issue, so there's a particular article that we wish to introduce. So could you explain the background story, please?
Yeah. Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today, this morning paper explained that those employees who received the allowance and they pay the corporate tax rather than income tax. So when they served more than 1 year, whether they will be qualified for severance pay or not, I think it becomes very big issue. So how to judge whether they are employee or freelance or non-employee? So this main issue based on whether they are really employee according to the article 2 of the Labor Standard Act. Definition of the employee provide labor service in return for the receiving wage under employee's supervision and control. So in this definition, we have to understand they must work under one particular employee. Also, they must receive wage or salary that is reward for their labor service. If they receive the commission from third party, it's not wage, only the wages they receive from directly from particular employee. Then, so whether such employee who served there more than a year and can be eligible for severance pay. So severance pay means anybody who served 1 year working for the particular working at a particular workplace, then they'll be eligible for 1 month salary for each service year. We call it severance pay. So the severance pay is only valid to the employee, not the freelancer. So we have to judge whether the person who has worked as employee or not. So I think many people nowadays who are receiving their allowance and they pay corporate tax rather than income tax. Also, they are not registered for social insurance. Also, they have some service contract rather than employment contract. Then in this case, we wonder whether they are employed or not. Then usually when they served in one particular place for more than a year, and they asked for a payment of severance pay. So in that case, this issue become a main point. Yeah. So there are several cases they are asking to this labor law firm whether they are eligible or entitled to severance pay or not. So we explain based on concept of Labor Standard Act, employee status. So this is how we advise them. If they served as employee, they are qualified for severance pay, even though they have a different service contract or they are not registered for social insurance. Also, they pay only the corporate tax, not the income tax. So we judged them based on actual fact, like based on concept of Labor Standard Act.
I see. So this is why that there's always a dispute whether the target person is employee or like part-time worker. And I understand that you have already prepared a checklist several years ago to judge whether this is a full-time employee or not and eligible for the severance pay.
Yeah.
So could you introduce what this manual is?
This part, also, I published this book, the manual on irregular employment and employee status. So this book is all sold out, so I'm going to republish it. the book, but I want to divide the two topics separately. One book is manual for unemployment, like irregular employment. The other book is the manual for the employee status. So this issue is very important nowadays, especially employee status. So there are many jobs they are treated as freelancer, but they are not freelance. They are employee. For example, truck driver who provide exclusive service for delivering some goods. So in that case, whether driver can be employed or not. Also hairdresser. So they are working exclusively for the shop, but their salary based on some their percentage of their contribution, like based on the person who they supported. Then they received maybe 50% of the income they contributed something. Yeah, then they are freelancer, but or maybe like working partner, but who hairdresser who received the base salary and they receive the incentive, then they are regarded as employees. So I think in such a cases we calculate based on this category. Like there are checklists for determining employee status. So according to Article 2, the employee definition of employee means someone who provide the labor service in return for receiving wage under employee's supervision and control. So in order to be employee, they should be under employee's supervision and control. Also, they earn the salary, not some allowance. So this money based on their the work provision. So there are two parts, like wage and the employee's supervision and control. So these two parts is important in the time of judging whether they are employed or not. Yeah. So this checklist it showed such a how we can judge them. Yeah.
So it means that the employer in normally they don't want to pay severance pay and big overhead costs. So they would maybe like to employ or utilize some labor work under like part-time job. But we need to look at the case by case whether that person is a full-time employee or just freelance worker. Just by defining a few categories is not enough. So we have to go into deeply into case by case.
Yes, yeah. So some judges or some labor authorities, they evaluate cases based on particular items, like they receive a regular salary, or they have been working exclusive for a particular employer. So I think it's a very one-sided. It should be judged collectively. What they earn, how they earn, also how they worked. So two parts, this checklist for determining employee status will play very important role to clearly explaining whether they are employed or not. So even though they have been working for a particular employer for years, but still, if they worked as an employee, then they are entitled to severance pay. So it's the opposite way. If they have been working for many years, but what they earn is some their main role for earning money. So, for example, like hairdresser, based on each customer, they earn based on each customer's income, like 50% of what they pay. So it is a business partner rather than employees. So we have to judge the case case by case based on this checklist I provided.
I think I see. So those who are not sure whether they're full-time employee or not, I think if they come to us, we can provide the right consulting legal service to define whether that person is full-time or not.
Okay, thank you for mentioning that. Yeah, this Gangnam Labor Law Firm provide professional service to support you, like employer side, also employee side. We are supporting based on this the checklist. So based on each job characteristic, so we try to find each factor to satisfy this the qualification. So please come to Gangnam Labor Law Firm. I'm sure we'll support you to get what you want. Yeah.
Thank you very much.
Okay, thank you for watching. Okay, bye bye.